Code of Professional Responsibility. Introduction to Canon 15. A lawyer shall observe candor, fairness, and loyalty in all his dealings and transactions with his clients. Generally, a lawyer may only be as successful in the practice as he has enough paying clientele. Without clients, a lawyer may not be able to make a name as a practitioner, though how talented he may be. On the other hand, a lawyer cannot just accept any case, nor can he employ business methods to solicit professional employment or to advertise his talent and skill to attract prospective clients. Rule 15.01. A lawyer, in conferring with a prospective client, shall ascertain as soon as practicable whether the matter would involve a conflict with another client or his own interest, and if so, shall forthwith inform the prospective client. It is the duty of a lawyer to disclose and explain to a prospective client all circumstances of his relations to the parties, and any interest in connection with the controversy, which in his honest judgment, might influence the client in the selection of a counsel. The disclosure is more for the protection of the lawyer than that of the client. If a lawyer conceals the fact that the adverse party used to be his client, the new client may have reason to suspect, in case of an unfavorable judgment, that the circumstance prevented him from the full discharge of his duty. Concealment of facts material to employment may cause his client to lose confidence in him. Duty to decline employment. A lawyer should decline professional employment even though how attractive the fee may be if its acceptance will involve a violation of any of the rules of the legal profession. After giving advice to a plaintiff concerning a claim, the lawyer may not thereafter accept retainer from the defendant to defeat that claim. He may not accept employment from another in a matter adversely affecting any interest of his former client with respect to which confidence has been reposed. Nor may he handle a case to nullify a contract which he prepared. He should not accept employment as an advocate in any matter in which he had intervened while in the government service. This canonical injunction is based upon the necessity that professional integrity and public confidence in that integrity be maintained. He may not accept employment from an organization to render legal services to members thereof concerning questions submitted by the members, the answers to which are printed for circulation. He may not accept employment as a columnist to answer inquiries for advice as to individual rights through the medium of a newspaper column. Nor may he accept employment from a collection agency which solicits business to collect its claims.
Exceptions. Rule 14.03. A lawyer may refuse to accept representation of an indigent client if he is not in a position to carry out the work effectively or competently. He labors under a conflict of interests between him and the prospective client or between a present client and the prospective client. Case. Jean Rosa Budet and Benito Belice, petitioners. Versus attorney Harold M. Hernando, respondent. AC. Number 1359. October 17, 1991. Facts. In an action for partition instituted by Jean Rosa as compulsory heir of the deceased Teofilo Budet, respondent was counsel for Luciana Abadilla and a certain Angela Budet. Involved in said partition case was a parcel of land identified as Lot 9439B. Respondent ultimately succeeded in defending Luciana Abadilla's claim of exclusive ownership over Lot 9439B. When Luciana died, respondent withdrew his appearance from that partition case. It appears that Luciana Abadilla sold the lot to Benito Belice and a new transfer certificate of title over the lot was issued in the name of complainant spouses. when an action for specific performance was lodged by a couple named Luis S.Y. and Elena S.Y. against Benito Belice as one of the defendants, the latter retained the services of respondent attorney. Hernando however claims that he rendered his services to Benito Belice free of charge. Respondent avers that the relationship between himself and Benito Belice as regards this case was terminated on December 4, 1969. On February 23, 1974, Respondent Hernando, without the consent of the heirs of Luciana Abadilla and complainant spouses, filed a petition on behalf of the heirs of Carlos, Dionisia, and Francisco all surnamed Abadilla, seeking the cancellation of the transfer certificate of title, TCT, of complainant spouses over the lot. Carlos, Dionisia, and Francisco were Luciana's registered CO owners in the original certificate of title covering Lot No. 9439B. Complainant spouses, upon learning of respondent's appearance against them in the cadastral proceeding, manifested their disapproval thereof in a letter dated July 30, 1974. At the hearing before the Office of the Solicitor General and in his answer, Respondent Hernando admitted his involvement in the cadastral case as counsel for the Abadillas but denied having seen or taken hold of the controversial transfer certificate of title, and having availed himself of any confidential information relating to Lot 9439B. Issue: whether or not attorney Harold M. Hernando represented conflicting interests and thus has violated Rule 15.01 and Rule 15.03 of the Code of Professional Responsibility. Held: yes. Attorney Harold M. Hernando is guilty of representing conflicting interests. Ratio: the mere fact that respondent had acted as counsel for Benito Belice in the action for specific performance should have precluded respondent from acting or appearing as counsel for the other side in the subsequent petition for cancellation of the transfer certificate of title of the spouses Jean Rosa and Benito Belice. This stern rule is designed not alone to prevent the dishonest practitioner from fraudulent conduct, but as well to protect the honest lawyer from unfounded suspicion of unprofessional practice. It is founded on principles of public policy, on good taste. The absence of monetary consideration does not exempt the lawyer from complying with the prohibition against pursuing cases where a conflict of interest exists. Thank you.